Nancy Lorraine Hoffman is out of the room for a moment, so we're going to take a question for someone other than her. So go ahead right here. And if you could try to speak as loud as possible, I'll repeat if necessary, then I'll hand the mic over to the speakers.
Okay, my question is for Ken. Ken, you said that they had to supply a notice if they were going to take your property through compulsory integration. Could they have bypassed that?
Okay, I will repeat. I'll summarize the question, but if you could.
No. Can they bypass it by putting an ad in the paper and not sending a letter?
The question is, do they have to send a letter? Can they bypass that by putting an ad in the paper, a notice in the paper?
The short answer is no, they cannot. They have to follow the formal notice procedure in the statutes.
Over here, please.
Our property is bordered on two sides by state land. If the DEC owns, thank you, if the DEC owns a majority of the acreage in a spacing unit and has leased it for gas drilling, is it not a conflict of interest for them to run the integration hearing and the adjudicatory hearing?
Well, technically, the DEC would not own the land. The state would own the land. It's a state forest, you said?
Right, but they manage it, and they received $458 an acre to lease it, and they will receive royalties for it.
Sure. I mean, you know, there's an obvious issue there. You've got two players on the same side. That, though, becomes a political question. The state can lease land, and they're subject to the same the ordinances. Yeah. No, I understand. The response you would get is that you know, you have a statutory procedure that has to be met, and the fact that the state is the owner of the land is irrelevant. The DEC, in theory, is a separate organization, a distinct organization, and will abide by the regulations and statutes, whether the landowner is the state or any entity.
In the back, can the state be subject to compulsory integration?
Can the state be?
So if there's state land, can the state land be subject to compulsory integration?
Can the state land be subject to compulsory integration?
That's a great question, and I have never thought about that. I've never seen the issue raised.
According to the SDIs, the state is not going to lease forest land, but they can drill under it.
Okay. We'll take one over here, and then I'll go over to this side. So go ahead.
Could I protect myself from compulsory integration by setting up a lease with a land trust or with another entity where I had an agreement with someone who said they would not extract the minerals?
So the question was, can she have protection by setting up some sort of an easement or arrange it with somebody else?
No, and again, the short answer is no. That the state rights, the statute would preempt any other interest in the land.
Carol, did you want to add something to that?
Oh, no, I do know that the Finger Lakes Land Trust is looking at this issue and is beginning to. If you have questions, they'd be a good place to go.
Yeah, I think one of the bigger issues is how the spacing units are determined. It's really quite offensive to me that the companies get to define their spacing units themselves. So they have a pretty good idea when they're drawing them, where the minerals are, but they also know where the property owners are. And the map that we had, I don't remember it was yours, Sharon, right? Was a very nice one with the straight lines. They were all very parallel, worked. But there are maps where the spacing units kind of do little corners, and they go around the Yates sheep and the Hoffman beef, and get somebody else's land first.
Okay, over here, yes, go ahead.
What have other people said in our state legislature about this? Or do we have any support?
About what in particular?
About repealing compulsory.
Okay, so the question is, what do some of our other elected officials at the state level, what's their opinion about repeal?
I'm not speaking for senators. I'm not speaking for them. I haven't heard of anyone. But I can't say definitively that it hasn't been discussed by anyone. I haven't heard anyone say that they are looking at repealing this law.
Way in the back. Yep, white sweater.
Has anybody done any estimates or projection? Like when you look at a map of a county and you see all those land that's leased, let's say it's a gazillion acres. How is anyone projecting, when you look at something like that, how many more gazillion acres would be taken by compulsory integration?
So the question is, has anyone looked at the areas that are leased, and then how many additional acres could potentially be taken by compulsory integration? Who would like this one?
Again, I can give you a resource more than an answer. There's an organization, TC Gas Map, and you can go to tcgasmap.org. There's a representative here in the room if you want to add anything, Sarah. They have looked at, to the extent possible, they went through the county, the deed records in the county clerk's office and have mapped out where there are existing leases, and then one of the TCOG Gas Drilling Task Force working groups, one of the other active ones is a mapping subcommittee, and at that same website you can link through to their work, has taken those maps and projected where there seem to be a critical mass of leases that would be the likely places that a company would then look to engage the additional 40% of the acreage in that square mile area.
Red shirt back here.
Thank you very much. I'm looking at the New York State Bar Association Journal, the issue of December 2011, November 2011. And we've discussed amending or repealing, but in this article they mention the constitutional issue. Now apparently the prior compulsory integration law, the one before 2005, was challenged, and the New York State Court, citing the United States Supreme Court, upheld the right of the state to use compulsory integration. But that was the old kind of compulsory integration. And in fact, when they cite the United States...
And what is your question, sir?
Here is the... there's only 2 lines. It says, the state has constitutional power to regulate, to secure equitable apportionment among landowners of migratory gas. Now, the gas does not migrate when it's locked in the shale.
And, sir, your question is?
So the question is there still a constitutional challenge because the gas does not migrate until trespass has happened? And we can explore this.
We'll let Ken answer the question, and I think we understand it.
I only wish I could answer the question. Big issues. Yeah, in the Sylvania versus Kilburn back in the 70s, you're right, that upheld the constitutionality of the older compulsory integration. I'm not aware of any current constitutional challenges to the current statutes, and whether there will be any, I don't know. There is some, I'm obviously not an expert in Texas law, but there are some cases out there now having to do with trespass, but the regulatory scheme out in Texas is entirely different from New York. I don't know that we can take a lot away from those decisions. But I understand the point you're making that hydraulic, the migration you're talking about emanates from law of capture that I talked about earlier. And the trespass you're talking about is the actual fracking and breaking of rock. But as I said, I'm not aware of any current litigation on that.
I actually have a question for the other panelists about this, because I'm interested in this notion of, is there a public purpose to compulsory integration or forced pooling, as it's known in other states, a rationale for traditional drilling, low-profile drilling, where that people were used to, where the gas is taken from under your land, but down the road. So my question is, Chip Northrup was the one who really first raised this question. If you base the distinction on the science, on the fact that the geology is different, that it isn't a pool of gas, it is needing to blast under people's houses, do you think that there is both a tactical distinction that could be made that could be more successful and a rationale, or do you think that that's sort of a false argument? To repeal, to do what? To call for repeal of compulsory integration as it relates to hydrofracking, high volume slickwater hydrofracking, as opposed to asking for full repeal where it relates to traditional drilling.
It's all very speculative. I think there may be some opportunities in more than one area for court action. I think theoretically legislation could be done. But it's theoretical. I'm not right now, unless we get a lot of senators talking about doing this. And frankly, I'm not even positive it could go through the Assembly. We've gotten a number of bills through, but we're not going to keep just putting bills through without any action in the Senate. It just doesn't happen, generally speaking. So we would have to see something happen in the Senate on this, and I'm not aware of any action happening unless someone here knows something that I don't. Maybe some of you have talked to senators and you're hearing things that I haven't heard yet. But practically speaking, politically speaking, we don't seem to see anything happening. I don't see anything happening right now in the Senate, unless there's massive public pressure. And I think, one of the cardinal rules of politics is that politicians, especially state legislators who spend a great deal of time running for office, it's a great deal of work to run for office. They generally don't want to be voted out the next time around. They generally want to stay a while and do some work. And so they very much care about what the people they represent think. So I think it's always worth trying to mobilize enough people in the public to change a legislator's mind that already maybe even seem to be made up. So I think it's always worth the discussion.
In the far back on this side, the gentleman. Okay, well, let this go first.
I just want to add, I agree totally with what your Assemblywoman said, and that's why the opportunity to present a cogent demand for something simple is the best thing. Instead of saying, well, we want to repeal or we want to amend it as it relates to hydrofracking. It's much easier to walk into a legislator's office. You walk into a senator's office with a simple agenda, and the way the land stewards are set up, we have 3 very simple goals. We could have had 5 or 6, but they're very simple. Repeal compulsory integration, which allows drilling for natural gas without landowner consent. Pass a landowner's Bill of Rights to protect landowners from predatory leasing practices, misinformation, and the right to full compensation. And establish a compensation and remediation fund for damages that could occur from drilling, so that the landowners and municipalities don't have to sue. It's fine to have a gentleman's agreement or a lady's agreement, but I don't think there are any land women out there. It would be different if there were. But having been given an assurance that everything's going to be okay in this town and we're going to fix all those roads that our trucks go over. But then the company gets sold, and there are problems, and they've subcontracted with some other vehicles, other trucking companies, and then you've got a poor town highway superintendent has to go before the town board and say, we're looking at about $500,000 in damages here, that we weren't expecting. That's why there needs to be an independent fund that's maintained by the state out of gas revenues, so that all of those things can be taken care of. We have other examples of funds like that are set up outside of industry control to protect interested parties that would not otherwise be able to file lawsuits to collect. So those are the idea is 3 simple things. When you go to a legislator, you have something very simple and you can put them on record. Now, in the final analysis, is it possible that you might get 2 out of the 3 and the compulsory integration might be changed a little bit? Yes, that's the kind of thing that does happen. But go for the max. Go for the whole thing and do it as simply as possible, and do it in a way that you can explain to somebody on a sidewalk or outside of church on Sunday afternoon in 5 minutes or less what it is you're trying to do, so that they want to be part of what you're trying to accomplish.
Okay, the gentleman in the back who I called him before. Okay, you need to speak a lot louder.
Compulsory integration, how does that apply to Indian reservation land?
How does compulsory integration apply to Indian reservation land?
It's another good question that I have not thought about, but Native American lands are sovereign. If it's a sovereign nation, I would think their position would be that there's no jurisdiction. I'm speculating.
Okay. Gentleman over here.
If the Dryden zoning, or town of Dryden zoning ordinance is upheld in this lawsuit that's going on right now with the Anschutz Petroleum Company, if that law is upheld at some point, I presume it's going to have to go all the way to the Court of Appeals. But wouldn't that rectify the entire situation? Because Dryden would have essentially zoned against gas drilling in the town of Dryden, which is where we stand right now with the Dryden zoning ordinance.
It would mean it wouldn't happen in the town of Dryden if they uphold local control.
So for those of you that just didn't hear, the question was about the town of Dryden and the current lawsuit around the ban on hydrofrac or gas drilling here in Dryden.
Essentially, they've zoned against hydrofracking.
Right. So you'd have local control, and Dryden and many other municipalities that have signed bans would be able to control it, either restrict it or ban it entirely. If it goes, as you say, I think it will probably go up to the Court of Appeals. And could it go beyond that? Could it go further? Is that the end? Could it go to the Supreme Court?
State constitutional issue because of the, it would seem to me. I read the briefs on both sides with that petition, and it seems to me I wasn't convinced by either side. So it seems, number one, it's going to have to go to the Court of Appeals, and number two, I would think it's does Dryden have the right to control their own land?
Well, I filed an amicus brief in the case, which is on my website, and I certainly argued for the local control. I do think the case law is there to support it, as well as the state constitution that assures home rule. Yep.
Here in the second row.
Several people have been advised, since gas drilling may occur around them, to lease land to themselves, form an LLC, so that they are protected. What kinds of protections does that provide?
The question was about forming an LLC. What kind of protection might that provide?
Yeah, I'm not sure I fully understand. You're saying if you create an entity to own the mineral rights?
No, you own the mineral rights, but you create an LLC.
Well, the LLC would still be subject to compulsory integration.
But so what does an LLC do for somebody? What kinds of protections that they wouldn't ordinarily have if they were integrated?
Are you referring to creating an LLC to protect yourself from liability? Is that what you're getting at? Yeah. If you were subject to compulsory integration and you wanted to lease to an entity that you create, you're the principal of, that is a way to begin to protect yourself. Nothing's foolproof, but you want to have an independent entity. You would need to strictly respect that entity as an independent organization, comply with all the requirements, state requirements for the entity, whether it's an LLC or a corporation. The courts look for capital in an entity to uphold its independence. If there is no capital, they look for insurance. Then you get into standard insurance policies or specialty industry insurance policies, which could be very, very expensive. But yeah, you're on the right track as far as trying to shield yourself from liability.
Gentleman over here.
Thank you. I'm on a committee that's analogous to Carol's committee, but I'm in Schuyler County. And when we talked to the director of the assessments for Schuyler County, he noted a chart that was similar to Carol's. and it kind of blows a bit of a hole in the reliance on the increase in property taxes. You've got to realize that the production of gas from a well is completely a voluntary admission by the company, that nobody in the assessor's office is anywhere near the professional capability to actually know what comes out of the well. Secondarily, how they list their expenses is a matter of oil and gas industry accounting practices that, once again, the assessors have no idea about. So when you come around to thinking about higher property taxes from these kinds of activities, you've got to be very careful and not trust the gas companies that you're going to have a good solid bump in that, but the landowner might be caught in the middle of that kind of a transaction.
And do you have a question, sir?
I just wanted Carol to react to that if she has any information that she can share with the rest of us about the charts that she put up with respect to that suggestion.
Well, the whole process gets worse than that. In New York State, there is nobody really responsible to read and verify the gas meters other than the gas companies. It is self-reported. The meters themselves, the type of meter, the brand of meter is approved by the PSC, the Public Service Commission, but the individual meters are not inspected for accuracy. The county has a Department of Weights and Measures, consists of one person, and it is his job to go around the county making sure that all scales and measures are accurate. So when you go to get gasoline in your car at the pump and that meter goes ka-ching, 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 and you have faith, you can have some faith that that's been checked, that a gallon of gas is a gallon and that you're not being shortchanged. You buy a cord of wood, you measure a scale, but there is nobody responsible to go and actually verify that those meters are balanced and accurate. The measurement of production is self-reported by the gas companies. The meters are not installed, as I've heard, and I haven't verified this for myself, but they say that the meters are not installed right there where the gas comes out of the ground. They are installed somewhere a little bit down the line. And any initial gas that gets off-gassed is not, it's never, they're never even pretending to capture that. Then, after the figures are plugged into that tax formula, and that tax formula was created so that each county assessment department or town assessment department would not need to know how to do anything too complicated locally. A figure comes out of that formula and is given to them. They then take the read that was self-reported by the gas companies, takes another 6 months to a year to get to the local offices, and plugs it in for the bill. Now, realize that production can happen in year X. Your expenses for your town are incurred in that year. That's the year you've got those extra trucks going through your town and potential environmental effects and workers coming in needing housing and all of the other things you've heard about in other sessions. But the production is not reported until the following year, and then the tax bills are set the year after that. So you've got there's the third year before you're seeing any revenues. Now, your budget was set for the year that production occurred in the year before that. So add an extra year because it's harder to change your budget mid-year. Now add to that the fact that many companies, in order to establish their rights, are coming in and drilling the wells so that those leases don't run out, because people are not as happy to be re-upping these days. And so they're drilling some wells, but they're not necessarily taking production right away. The price of gas, as you've heard, is down from a high of $12, it's a metric, I know, a 1,000 cubic feet, MCF. And because the price of gas is now down to $3.63, I think, for one of those units, and gas companies can't make economic viability from those wells until it's up at least at 4, preferably higher to 7. they're actually capping and waiting to take production. So all those expenses that we've incurred on the local level in year, we've set the budget in year X minus 1. They've drilled in year X. We don't even pretend to get the money till year X plus 2. And then for any years that well is capped and there's no production, we won't see any revenues. So it's a real problem.
I have actually a two-part question. Number one is you were referring to liability. So if I'm compulsorily integrated and my neighbor is not in the spacing unit, and can I be held liable for some ill effect that happens on their land? And then the part two is, has anybody ever gotten out of compulsory integration when they go to the hearing? What are reasons how people can get out of being integrated?
So there's a question about liability, that if she was compulsory integrated but the neighbor wasn't, and there was some sort of damage, would she be liable for what happened to the neighbor's property? And then, has anyone ever gotten out of being compulsorily integrated?
On the first question, you would never be liable if you choose to be a royalty owner if you're under compulsory integration. You do have the liability issue that I mentioned as a non-participating or participating owner. And as far as the compulsory integration hearing, the sole purpose of the hearing is to determine whether the application is in compliance with all of the statutory and regulatory requirements. It's not a hearing, it's not an equitable proceeding, it's not a hearing to where you can raise objections based on your opinion of the law, that type of thing. It's solely to determine that the application and the operator is in compliance with the statutory and regulatory requirements.
And over here next.
Can municipalities sue an integrated landowner if that municipality's water supply is damaged? I'm thinking Cortland Homer, Newark Valley, other smaller villages that we know don't get surface lake water or river water as their supply. I have possession of an expired lease that has an indemnification clause in it that says even if I'm only integrated, I could be liable. I could be liable. That was the indemnification or the indemnity clause in it. That scares me a little bit, and I think...
So an issue of liability, especially if a municipal well was contaminated and you were part of that drilling unit.
In relation to the first question, I think there is an issue. As a participating or non-participating owner, you are liable for your proportionate share of claims related to the wells. It's a broad provision. So there's no limitation that I'm aware of to those types of claims. On the lease issue, I'm not sure I understood the question. Usually you negotiate an indemnification from the operator, not the other way around.
Right, and excuse me, the indemnification, the indemnity clause said that they will indemnify me if it can be proven that they made the damages, and of course that is a very speculative thing.
Well, yeah, that's something you want to flip. You want to flip the burden of proof in negotiating the lease. But unfortunately, many people sign the draft company leases.
Read it.
Go ahead.
Thank you. Based on what you told us tonight, it seems like there is some grounds for a legal challenge, a judicial challenge, since shale does not migrate. Do you know of any effort along those lines in the state? Is anyone?
So a question about if there's grounds for a legal challenge and based on the non-migrating nature, and does anyone know of such a challenge that's underway?
I'm not aware of any current challenge. I've heard all along that at some point, once we get through this whole DEC process, we'll see major environmental groups come in with a lawsuit. Whether it's on that basis, I can't say for sure what the premise of the suit would be, but that could be certainly one of them, maybe. But I haven't heard specifically.
This is maybe a good opportunity to let you know that there's we've got some draft comments and the importance of commenting in general on this and other issues. Because what I've heard from some of these major environmental groups is that their challenge will partially be based on people participating in the process that we've been handed. So that the extent to which they can show that people around the state have expressed concerns, have weighed in, will strengthen their ability to wage whatever legal challenges they're going to go and wage. In that regard, Greg and some other of the lenders have put together a draft letter. This is hot off the presses just today, and may still go through a couple of words here and there that they are urging their fellow lenders to submit, but we thought it might be useful for people here to see what those comments are, and certainly all of you are welcome to enter those comments. I will say that this letter is in particular meant to focus only and specifically on the mortgage issue and on the ways in which New York State could fix this issue in particular. So it is calling for that 300-foot setback. It is in no way meant to weigh in an environmental manner as to what would be environmentally safe distance for this activity to maintain, for the state to maintain between this activity and your dwellings. So Greg has this letter. I don't know if you want to rustle papers or put them in the back, but it's just an incredible thing that that they have put together. Cite chapter and verse and the most important points for us to use. So thank you.
Red shirt and then the brown sweater.
Yeah, this is for the Assemblywoman and former Assemblywoman. Wouldn't the easiest way, given the way people voted this past Tuesday, wouldn't it be the easiest way to repeal this law is to get us a list of the senators and assemblymen that are against repealing it, and then let the people take care of it? We'll take care of it.
So the issue was about getting public word out about what senators and assembly people are opposed to the repeal and making that publicly known so that people can consider that when they vote.
Well, that's part of any campaign to put, as Senator Hoffman said, former Senator Hoffman, to put your request in writing and say, do you support this or not? Can we get your help with this? And then yes, you publicize the results of that effort. That's just what you do.
You're absolutely correct, and it sounds so succinct, but that was why I said 3 simple points, because the minute you present a whole broad spectrum of things, we're pretty artful dodgers, you know. You want to be able to go back and say, I met with you with a group of other people. We talked about the land stewards agenda. We want to know whether you are for or against repeal of compulsory integration. You want to enact a landowner's bill of rights. You want to establish a compensation and remediation fund. You get them on the record doing that. And many will be happy to do that, and many will appreciate the opportunity to hear from their own constituents about that, especially if you approach them civilly, because I guarantee you a large number of them don't really understand how significant this is, and they never heard it from people who are directly affected. They heard from the industry. They didn't hear from the landowners and how things were presented upside down from the way they really are. So give them a chance. And this has to be done all over the state, because as the Assemblywoman said, you have to have a majority in each house to pass something. So you can get up close to November a year from now and have wasted a lot of time just talking in very general terms about the sky is falling, somebody's got to do something. But don't waste your time. Be specific. Go see them. Have a unified agenda. And then they all know. And that's worked very successfully. We can give you lots of examples how that's worked. One good example, toxic torts legislation. This was the last state in the nation to change the date from which you could file a suit for damages if you were a DES baby or had suffered asbestosis or hard metals disease. Every other state in the nation had changed that law to allow people to sue from the date of discovery rather than from the date of exposure, because the date of discovery could have been years after the date of exposure. And it was the Senate that was the holdout, because it was going to cost a lot of money, and the industries didn't want to see this happen. Well, it was a very big issue in my initial campaign in 1984, and one of the things that made a difference in that election was that my opponent didn't want to talk about that. He said, well, that just didn't come out of the conference room. And I kept pushing him, saying, well, how did you vote in conference? Just because it was behind closed doors, you got to tell us how you voted. And pretty soon there were a lot of others that recognized that the same thing could happen to them that happened to the gentleman that I defeated. So you have the opportunity. Use it wisely.
I was told, and this is more of a statement than a question of the equipment, that you can hire your own company to monitor and maintain your own equipment. Is that something you...
So the question is can you create your own company to hire and monitor the equipment?
No, there are contractors that do that for us.
Oh, there are subcontractors that will do that for you to monitor. Okay. So the comment was just, yes, you can do that, but it's expensive. Did anyone else want to comment?
I can tell you just water monitoring, for example, you need to monitor your water, I think it's every 6 months, in order to show that you knew the quality of your water, and it costs, I think, minimum $500 each time. $600, the price keeps going up. Do I hear 700? But you know, it depends on, there are a whole host of things you can test that water for, so it depends which
I'm talking about the environmental, I'm talking about the actual equipment, drilling equipment. There are companies that actually monitor for the lessee, not the company.
Yeah, I mean, I'm sure you can do that for a price. Again, it's very expensive to hire that kind of assistance, and should it be the individual landowner, especially one who's been compulsorily integrated, who has to bear that cost?
Up here.
I have a question regarding they're exempt from the Clean Water, Clean Air Act. The issue you just mentioned, we've been testing our water, and we're going to test it every year because we're concerned about what will happen. But my concern is are these guys, are they liable if they pollute your water? And does it change if you're forced to come into compliance, whether at any level? Does that change their liability to you?
The question is, are the companies liable if they pollute your water, and does that change whether you've signed a lease or you've been compulsorily integrated?
I think it's in either case, whether you've signed or not signed, they are liable for damage. Anyone's liable, a company or an individual is liable for damaging someone else's property. Our current law calls for that general liability. I have a bill that changes it to strict liability, just like we have with our petroleum law in New York State, petroleum spills. So what does that mean? With strict liability, with regular liability, you have to prove gross negligence. You have to prove they did something they shouldn't have done. With strict liability, it's just all you have to do is prove that it was caused by this event, by this action. They did it. And then it's very hard to prove that a gas company on your property or your neighbor's property engaged in gross negligence. How do you do that? So it's very hard right now for individuals to hold them liable. But of course, it applies to both landowners and to the company, strict liability. That bill is sitting in both houses. It's a more difficult bill to deal with, but that's the current law.
So at this point then, if DEC decides to go ahead to start giving permits, before these quote-unquote protections are in place, then the landowner's just stuck.
Well, obviously we're going to fight to make sure that full protections are in place if and when this goes forward. But yeah, it's one of the worries. That's why so many people are arguing that we're not ready for this, that the industry is not ready to come in. We think there's too much risk, and we've seen too many instances, and we just saw another one a few weeks ago in the Journal that Walter Heng dug up the case where their water was destroyed, and the DEC did not come in and protect them. I've seen it in Pennsylvania. I've been down to Pennsylvania twice now, and the industry just walks away. We've got 70 people with with destroyed water wells in one county, in Bradford County. And the industry says, well, we're not really liable, but we'll give you some water, and sign a non-disclosure agreement. They walk away. We didn't cause it. It's natural methane in your water, or it's something came from somewhere else. It's very hard to prove. But, many people are in court in Pennsylvania trying to prove these things. There are a lot of lawsuits going on in Pennsylvania now.
Just add one brief comment. Where you do have control is in a lease agreement. You can negotiate the lease agreement, and again, it comes down to burden of proof. Absent any negotiation of the lease agreement, if there's a water contamination, you would have the burden of proving that it was the operator that caused the problem. If you negotiate a shift in the burden of proof, you put in the lease agreement that if you have to have baseline water testing, if the water is subsequently contaminated after operations start, the presumption is that the contamination was caused by the operator, unless the operator can prove another source unrelated to them. It's all about shifting the burden of proof, and you do have control when you negotiate a lease, and the operators will work with you on that.
The woman, go ahead.
I have a question for Greg. Louder, please. Oh, I have a question for Greg about the secondary market and all the drilling that's been happening around the country. Whether it seems to me there's been quite a few technical violations on these mortgages. Are the secondary market, are they acting on any of these problems outside of New York?
The question is, what is happening in the secondary markets, given how much gas drilling has been going on around the country?
If you look at the the draft FGEIS in section 8.4, you will see that the state actually looked at a number of setbacks in other states and listed a significant number of them, 8, 10, 12, listed at far more than 200 or 300 feet. So they acknowledged in the SGEIS that the issue was resolved in other states by having greater setback.
But there's people that have had drilling on your land where it says you're not allowed to have, for the title insurance and things like that, you're not allowed to have, commercial activity on your land, and people are obviously doing it. They're not getting in trouble.
And in other states, it is prohibited by law to be at a further setback, which then sort of takes care of the secondary market problem. Here, we've got a problem because New York's regulations say 100 feet setback from a private residence and 150 foot from a commercial residence. So one of the reasons, and on the back of the letter that I circulated here, there's two things we're asking for, and I think they go along with the compulsory integration issue. One is, expand the setback agreement, and do it so that it's not just on the surface, but the surface and subsurface rights, and we start to block the ability to be compulsory integrated. They're going to have larger tracts of land under lease. So that's one of the ways, and that's in the letter that I circulated just a minute ago.
Way in the back.
Do you think the setback issue is a larger issue than having the industrial infrastructure either under the land in the case of the compulsory integration? Is that
do I think that the setback issue is larger than
the issue of having this industrialization?
If you get setback back past the 200, 300 foot level, title insurance companies are issuing title insurance without those exclusions.
So, but what about the host of problems you were talking about having this drilling going on under the land?
Again, why I'm suggesting subsurface needs to be addressed as well. So my letter, if you look on the back page, or a draft letter, there's what we're asking for, what we believe could be beneficial is to establish the setback that's not just on the surface, but on subsurface. It will not allow any subsurface activity within 200 foot of that wedge to the center of the earth.
I think Greg is being modest here as well. I do think that there are some other states that set minimum setbacks, that are large enough to take care of some of this issue, the surface issues. Our sense from talking to some people around the country about this, is that this whole issue of the subsurface routing of those boreholes, possibly going under properties within that 200-foot setback requirement in that wedge to the center of the earth, has not fully been dealt with. Banks that have asked, lenders that have asked up at the federal and secondary market levels, what are we supposed to do here, I think got a little bit more of a shrug of the shoulders, and they're in business. And if your regulating agency and if your secondary market is saying we're not, sort of shrugging their shoulders and not very clearly coming back with the message that we are going to enforce this, you're going to keep doing what they did in the subprime mortgage crisis, where people shrugged their shoulders and said, have you fully qualified the buyers? And people said yes. But there was a lot of pressure to say yes with ever looser standards of qualification. Nobody designed a system. Nobody came in and said, we're trying to create a crisis. It slipped in. And I think that's possible that's happened here with these changed practices. And I think that now that this issue has come to the national fore, stimulated by people like Greg and the other lenders who have raised this issue publicly, and then followed up by the New York Times, and the New York State Bar Association just came out with an article about this, and others around the country have been calling us and asking, including, Attorneys General Office of several other states, and state people and congressional people have called and asked us, what have we discovered and what do we think? And they're looking into it, and it'll be interesting to see what the reaction is. It is interesting to note that FHFA, so Fannie Mae and Freddie Mac, are right now in a kind of receivership. They were a private market. They were put under public jurisdiction because they were not enforcing all of their standards. As part of that process, they've just instituted a new appraisal report process. It's their uniform appraisal data set, instituted September 1st. All lenders that are asking to sell their mortgages up to the Fannie Mae and Freddie Mac are required to enter a whole host of additional information into that data set to show that they've checked many aspects of the property, the condition of the property, what year your kitchen was updated, how many bedrooms you really have, all kinds of things in addition to leases. So there's evidence that this is starting to be looked at more closely, that FHFA has weighed in that, yes, this is something we expect the banks to have checked, and it'll be interesting to see where this proceeds.
In general terms, the guidelines, and I understand what Carol's saying, is we've gotten some letters directly from the regulating bodies that say it is the lender's responsibility to assure that they are in compliance with our standard regulations, and then list those regulations, 200 and 300 foot setback. There is probably lenders out there that across the country who have ignored that in the past. That could be a problem. I'm not trying to raise a red flag on that. I think we can solve the problem in New York by getting at least some attention to some of the points that we've brought up.
Great. I'm going to have to wrap this up. Our speakers have been very generous with their time. I will say I will try to get as many copies of things on the Cooperative Extension gas drilling website, so that instead of linking all over the place, you'll have one place you can go as a central. So we have, as a small token of thanks for our presenters, we have a lovely calendar that was provided by Fleece. So if I will pass those out while you all give them a riotous round of applause.